Hey everyone, what's going on? King here, back for another video. So if you've seen my other video where I talked about things were heating up with the legal fight over the heir property, and I've been involved in this legal fight since 2016 when I first hired the attorney to start the process to acquire a title. Here it is, 2023, and we're still in a legal fight, but not so much about acquiring a title to the property, but to find out who are the true heirs to the property, because it's still a question. I mean, the acquired title to the property has already been done, but now since members of my family and others didn't want to abide by the order, didn't want to abide by the agreements, accused me of do things under the table, committing fraud, submitting fraudulent documents to the court, lying, and a whole 9 yards, to include me being voted off the board for my position as the assistant secretary, that we're back in court. Back in the legal fight. We're not in court yet, but I filed a complaint along with my mother to deal with all the unresolved legal issues and the current legal issues, whatever case may be. And so yeah, the fight is heating up as far as in court, legally that is. So I want to go back to the beginning. Go back to, excuse me, when things first happened, as far as presenting the complaints to the court. I didn't find the problems in court because now this started in 2011, way before I came home, way before I got involved, and it was over the heir property. Members of my family who I'll cover here in the complaint, because I'm going to show you the complaint, talk about the complaint and the documents that were submitted to the court. Again, this is in 2011. They were involved in management of the property. They were involved in trying to figure out who were the heirs, owners of the property. But in the process of doing so, they were named in complaint as defendants versus individuals who, made the allegations of conversion conspiracy on their part. Right? So plaintiffs versus defendants. Members of my family were the defendants. The plaintiffs, in a way, in my opinion, did not want to determine how the court determined who were heirs to the property. Basically, to start the acquired title process back in 2011. Now, before I get any further into this topic in this video, I want to point out that, one, I'm not an attorney, so I'm not giving you legal advice, right? But I will express my own opinion based on my knowledge and understanding of the case, based on doing the research, based on reading the documents, and being a party of some sort in this legal fight since 2016. Legally, officially, that is in 2017. So, without further ado, let's just get into this topic of discussion. So what I'm going to do is I'm going to, show the complaint, right? So it happened here in the state of South Carolina, Marion County to be exact. You can see that there was the list of individuals there, and they were individually and collectively doing business as the Washington Association. They are named the plaintiffs. And then there's the defendants, where it consists of members of my family. They were allegedly, individually, collectively doing business as the Washington Plantation, and also was mentioned as a defendant, Carolina First Bank, which was the bank that basically housed the bank account associated with the property. Okay. So this complaint was filed in Court of Common Pleas with 12th Judicial Circuit here in South Carolina. You can see that there's the case number, and it was back in February of 2011. For some reason, why is that? Okay, there you go. Hold on, let me get this off of here. I don't know what is going on here. Okay, there it is. Sorry about that. So this is the facts of the cover sheet. Cover sheet. Okay, here's a summons. I'm going to read all that. Again, this was filed, or at least filled out, on the February 23rd, 2011. I think it was actually probably stamped on 24th of February 2011. So here's the complaint. So again, list of the individuals, the parties. So the plaintiffs versus defendants. There's my family or the defendants. The plaintiffs complaining of the defendants by and through their unassigned counsel allege, right, the parties, that the plaintiffs, you can see the names there, I won't read them all, claim to be heirs to Washington James Estate and members of the Washington James Association are all citizens and residents of the County of Marion, state of South Carolina, and bringing this suit in their individual capacities. Now, this part here, paragraph 1. I just want to stop for a second and talk about this. At no point in time did they actually file any paperwork to show proof that they are heirs. But here it says the plaintiffs, blah, 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 blah. Let me see. Heirs to the Washington James Estate. How they're heirs. It was never determined that they were heirs. So for this, his first paragraph is questionable. I would have questioned it, like, how are you sitting there saying that you're heirs? Prove it. They did not prove it. But we'll get into that later. Okay, number 2, that the defendants, you see there, are also heirs to the Washington James Estate, and 5 of the original members of the Washington James Association, and likewise citizens and residents of the County of Marion, state of South Carolina, and are being sued individually. Not collectively? Why not collectively? If they just said they're 5 original members of the Washington James Association, so why not collectively? Because the first one says individually, collectively, right? That's what it says in their. Well, I don't know. I'll question that too. I'll question that paragraph too as far as how it's worded. But okay, whatever. All right, number 3, that upon information believed, defendant Carolina First Bank, which is the actual other party, that's a defendant, is a banking association organized and existing under the laws of state of North Carolina and is authorized to do business in the state of South Carolina. Okay, so that's the bank account. Well, that's for the bank that houses the bank account. That the court has jurisdiction over subject matter and parties to its action. Okay, so now I'm going to relevant facts. The plaintiffs incorporate and reallege each of the foregoing allegations as if fully repeated herein verbatim. That since 1894, which is not true, approximately 1,000 or 618.81 acres of land of the Waukee Township of Marion County, South Carolina, commonly known as Washington James Land, aka Washington James Estate, herein after the estate has been owned by the heirs of the estate. Number 7, that in September 1975, heirs to the estate formed and legally organized the Washington James Association, herein the association which is governed by bylaws for the following purposes: A, to organize the estate in order to get working capital. B, to develop a close relationship with members and families of the estate, and to develop clear function groups to serve and improve the services for good management. I'm going to pause for a second and cover this topic. So, paragraph. Number 7, that may or may not be true, but where's the proof of it? Where's the evidence? Where's the documentation to back that up? They should have that. They should at least present that and file that with this complaint. Now, I mean, some of the documentation that I'll cover later in this video, because it might be a long video. You might have to break it up. I'm going to break it up with some parts, or it might be an hour, 2-hour video. I'm not sure yet. We'll see how fast I can get through this. But feel free to stop and pause it and come back at a later time to finish watching it if it runs longer than 30 minutes or an hour or whatever. But 1995, like where's the evidence of that? Like, based on what documentation? Was there articles of incorporation filed? Right? What paperwork are they referring to? Like, what paperwork or what information is this valid based off? Especially, paragraphs A, B, and C, because I've seen the hold on, pause for a second. Okay. I've seen the bylaws, and the bylaws that I used to draft the new bylaws mention these paragraphs, right? That's part of the, like you say, goal of the estate or association was to these topics, to organize to the estate in order to get working capital, to develop a close relationship with members and families of the estate, and to develop clear function groups to serve and improve the services for grease management. Now, it's my understanding that this part of the bylaws, or this information, the bylaws that it came from, was written or developed in 2006, so not in 1975. Based on my understanding, it was after 2006, maybe even between 2006 and 2011. So again, what are we referring this to? Like you said, the bylaws, but what bylaws? Especially when the bylaws have not been ratified by the heirs. And more than just the individuals that are named in this, that are parties in this complaint. Like, were all the heirs part of that conversation? Were all the heirs part of the ratification or bylaws to say that this is what we want, that we're going to organize the estate in good order to get working capital, to develop a close relationship with members of the family, and da, da, da. Did they agree to that? Was that part of the conversation? Is that on record? Is recorded in some meeting minutes? Is recorded wherever? So again, I would have questioned these first paragraphs. Like, this is just ridiculous. But anyway, continue on. Number 8, that from June 2003 up until April 18, 2009, the association was governed by a committee of 6 members who were duly elected in accordance with its bylaws: Robert Hunter, Jake James Jr., Alberta Nolan, Catherine Lester, Rosemary Nelson, and Marilyn Williams. So here it says 6 members up in 2009, but now a few paragraphs ahead it said that the defendants in the case were the original 5 members. So when did it change? So now it's saying 6, now it's saying 5. Wait, this is confusing. The way it's read in his complaint. But anyways, during this period, there were only 2 elected officers: Miss Lester, Recorder Secretary, and Miss Alberta Nolan, Financial Secretary. So how were there only 2? Where's the president? Where's the vice president? Or where's the, I think some of the paperwork it says there was a chairman, a vice chairman. Where's the paperwork at? Where's the evidence to back up these I guess you can call it allegations or statements? But I want you to pay attention to at least remember that I might cover it later in this video, again depending on how long it would take for me to cover this information, but if I bring it up. But Miss Alberta Nolan, as a financial secretary, there are statements, I believe, in her deposition, or not deposition, when she was cross-examined on the witness stand, that she said that there was never, or there wasn't a president elected, and I forget how many years, like probably early 2000s or mid 2000s, there wasn't a president. So how is this, organization, association, whoever, is functioning without a president, and her being the financial secretary, and you have a financial secretary and recording secretary. So you're not a full up board. You're not a full up, right? How are you functioning? How is this organization functioning, association functioning, board, whatever you want to call them, functioning without all of its members, without all positions filled? Again, why didn't they question this? Why didn't members of my family who were named as defendants, to include the bank, question this statement, paragraph 8? I would have questioned it. I would have said, we need to see evidence. We need to see proof of this. But again, this is just a complaint, right? So we'll get into the responses later. All right, number 9, that at all times herein mentioned, Carolina First Bank served as a depository for the association, and Miss Nolan was recognized by the bank as the authorized person for the association to transact its financial affairs under account, blah, 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 make deposits, blah, blah, blah. There exists a contractual relationship between parties. Number 10, that prior to Miss Nolan becoming financial secretary for association, Miss Anita Dudley served as a treasurer for the association, and in order for Miss Dudley to be removed from Miss Nolan, replaced the association account number with the bank, right? For both parties were required to report to the bank. Moreover, Miss Dudley had to equince, I can't remember, anyway, from Miss Nolan here to sign checks, and conduct the business for the association. So I guess it's saying here that in order for Miss Nolan to replace Miss Dudley, that they had to be present and had to give verbal or written acknowledgement that she was replacing her. Okay. For the business of association. And I believe that, again, I would question this because, if anybody's name was removed from an account, if Miss Nolan's name was removed from the account, right, the question is, was Miss Dudley, made aware of it? Right? Because I believe, based on, I could be wrong now, but based on the conversation I had with members of my family, that they went to the proper channels to do so. But again, I would question. I would have provided evidence to say otherwise, to challenge that claim, the allegation. Anyway, number 11, that the defendants, Mr. Brown, Miss Casey, okay. However, in April 2009, these defendants organized and began to operate under the name of Watch James Plantation, herein after the plantation, with the following defendants serving as board members, blah, blah, blah. You see their names there in petitions. Number 12, that in August 2010, when plaintiff Amber Nolan attempted to transact business with the bank on behalf of the association, her name had been removed from the association bank account, and the bank no longer recognized her as the authorized representative for the association. All right. Number 13, that in August 2010, the association received a bank statement indicating that, you see the dollar amount there, $21,000, had been withdrawn from the association's account. The bank and its balance had been reduced to $38,000. Number 14, the sole purpose of operating as Washington's plantation was for defendants to take control of the property, referred to in paragraph 6 of hearing complaint, take control of the plaintiff's bank account. Well, that's funny. It says plaintiff's bank account. Like, how did they? What? But I thought they said that they were part of that. They were part of the original association, or they were members of the association. So how is it that they're saying that the plaintiff's bank account when it should be the heir property's bank account? Anyways, the plaintiff's bank account held by defendant Carolina First Bank and for purposes unknown to plaintiffs at this time. Number 15, that as a result of the bank allowing for the plantation to take control of the association's account number, blah, 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 for which it was the depository, the association lost control of its funds and its ability to provide revenue for the association. Again, so I would question all of this because, one, were all these individuals that are named as a plaintiff, were they individually doing business as the association? They need to prove it, and they have not proven it. This isn't words on paper. Granted, they'll provide the response, or they as the defendants will provide the response, but I would have challenged all of this. I would have questioned this legitimacy and made them prove it. And if they couldn't prove it, then I would have filed a motion to dismiss the case based on the facts, right? Granted, it would take some time to do so. Like, it might take a year or whatever to ask the courts to dismiss this. But I would have used the legal tools available to basically gather information to prove this. Like, and it means having depositions, disposing people, asking questions, like disposing the parties involved, like Miss Alberta Nolan, Miss Catherine Lester, and whoever their mother, if their name is a party, I would have my attorney dispose of them, right? Question them, or have them answer questions, written questions, provide written answers to the written questions to gather that information, to gather enough information to build your case, to build your defense. But again, hindsight is 20/20, right? After the fact. But just reading this and knowing what I know now, I would have challenged it. Anyway, so now going to the cause of action. The first cause of action is civil conspiracy. I believe there's 5 of them here, but continue on. Number 16. The plaintiffs incorporate and reallege each of the foregoing allegations as is fully repeated herein, blah, blah, blah. Okay. The plantation, number 17, the plantation combined and confederated among themselves, individually and collectively, to control the state and deprive the association of its funds. The bank, through its conduct of transferring funds to the plantation, became part of conspiracy through its conduct and implied tacit agreement, which caused damage to the association. Number 18, the bank owed a duty to the association, and its conduct, as stated in paragraph 17 above, was direct and proximate cause of damage to the association. Blah, blah, blah. So, paragraph 8, failing to notify the association that its account, blah, 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 what, was being transferred to the plantation, failing to exercise due care as a depository holding funds for association. Okay, I'm going to skip some of this stuff here. Let's see. The plantation conspired and confederated and acted together individually in concert to violate the bylaws of the association as they relate to notice and election of officers. 20. The plantation further specifically conspired to exclusively control the estate and deprive the association of its rightful domination control. 21. The plantation interfered with the association's right to contract, which resulted in the state losing an annual hunting fee of $3,500. So they didn't even mention that in the facts of the case. They didn't even mention that. But they're talking about it here in the first cause of action. Like, it was crazy. You know, man, this is hilarious. This is hilarious. Okay, paragraph 21. $3,500. Now, there's even documentation where the individuals that are being sued in this case, known as defendants, right? Not all of them, but some of them, at least 2 of them, went to meet with the magistrate, the Marion County magistrate, in, I want to say 2009, 2008, 2009, maybe 2010, about the hunting rights. And the magistrate, now there's notes, there was notes taken by one of the individuals that were there, who was now named as a co-defendant in this case, where they took notes as to what the magistrate said in regards to the hunting rights. That it wasn't a valid hunting lease because the individuals that signed it were not individually and collectively doing business as the association, meaning that they did not hold officer positions and they had no business signing that agreement or signing that lease agreement, a lease contract, without all parties being, or the right parties being present, and 2, signing the document, signing the lease agreement. So the magistrate says it's not a valid lease agreement. There's meeting minutes to prove it. There's minutes or notes from that meeting with the magistrate and the defendants in the case, who were not, at the time they were not defendants, and it's members of the party, the plaintiffs. At the time they were not plaintiffs, but there was a meeting. Right? Again, another reason why I would have challenged this complaint against me if it was me. If I was a party in this case, I would use that to challenge the complaint. And at no point in time was it entered into part of the complaint or made, man. Anyways, continuing on. Okay, 22, the plantation wrongfully obtained the funds held by the bank, and as a result, deprived the association the legal and rightful owner of the said funds. I'm going to read everything. Let's go to the second call of action. A breach of fiduciary duties on the part of Carolina Bank. You see that, right? So this bank is being identified as a co-conspirator, if you will. I think that's probably the proper way of saying it. If I'm wrong, yeah. Again, I'm not an attorney, so. But they're saying that the bank had a hand in it, in allowing this conspiracy to happen, and that they violated their fiduciary duties. That for third cause of action, that the bank breached a contract because Miss Albert Nolan was supposed to be the financial secretary, and she's supposed to have rights to the property, rights to the bank account. What's going on with this thing? And so forth, so forth. Right. So the fourth cause of action, negligence on the part of the Carolina Bank. The fifth cause of action, conversion. So let's see here. Let me go back up for a second. Even the first cause of action. Okay, so first cause of action was, it mentions the plantation, it mentions the bank. So I guess conversion or civil conspiracy on both parts of the bank and the defendants, the co-defendants, the plantation. And then second cause of action, primarily the bank. Third cause of action, a breach of contract. The fourth cause of action on the bank for negligence on part of the bank. The fifth cause of action, conversion on the part of the plantation. So really it's only the first and the fifth cause of action is what talking about the plantation where they are alleged to have committed the conspiracy and conversion. 37, the plaintiffs incorporate and relocating. 38, the odd times here we mentioned association, blah blah blah. Okay, was the exclusive owner of the funds. They gotta prove that though. They gotta prove that deposit with the bank. Okay, because not everybody. And if I say that because if they were not individually doing business as an association, how are they the owners of the bank account? Especially if their names are on the bank account. If they not signed no contract or signing kind of documentation saying that they have rights to this bank account, how are they the owners of the bank account? Right? Because you got to prove it. You can't just walk off the street. Right? I say walk the street, but you walk into a bank and says, hey, I want to withdraw money from this bank account, from my bank. Oh, can I get your ID? What's your bank number? That's the first thing I'm going to ask. So my question would be, do all the people that so-called part of the association know, one, the bank account number, and two, know where it's located, and three, have access to the bank account? Do they? I would have questioned it. Again, hindsight 2020, but if I was a defendant in this case, I would have had my lawyer question it. Okay, the plantation 39. The plantation converted the funds of the association held by the bank and account, blah, 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 to its own use, thereby excluding the association of its ownership and possession of funds, blah, blah, blah. 40. The above mentioned acts were done without permission, knowledge, and consent of the association, where if the plaintiffs pray that the honorable court grant relief in the following, blah, blah, blah. So now they're asking for relief, requiring for the bank to give accounting of the funds, requiring the defendants to give accounting of all funds, requiring the defendants to do accounting of the dates the funds were, whatever, provide accounting for bank to provide accounting of any involved funds deposited, prohibiting cutting of timber from the property, requiring defendants to return any funds derived from the sale of timber. They know they didn't sell no timber, man. Like, it's crazy. Requiring defendants to provide accounting about funds, prohibiting use of funds from plaintiffs' account to defray attorney's fees and costs associated with any civil or criminal action, suspending any all hunting rights on property known as Washington Estate, belonging to the Washington Association, granting plaintiff's attorney's fees and costs associated with this action, granting such other and further relief as this honorable court may deem just and equitable. Now, okay, so that's the complaint. That's the complaint. And here, these pages here, or the verification where they, I guess, saying that they were individually doing business as the association, and they had interest in the property. Right, so they all signed it. So all individuals that are named as a plaintiff in the case signed this document. These documents, have their name. And it said that they were, upon being duly sworn, deposes and says. I would question that they were questioned before they signed this as to if all of the information that they're giving was the truth. Is it true? I would question it. I definitely would question it. Definitely would question as a defendant. If I'm the one that's being served in complaint, I would have questioned it. Let me see here. So here, looks like there was a plaintiff's emergency motion for ex parte temporary restraining order and preliminary injunction. So basically here they filed an injunction. Let me actually turn, why is it up? It's upside down. So let me figure out how to get this right. Oh, still is wrong. So they filed an injunction to basically, that's like a protective order against the defendants to protect the interests of the plaintiffs. So you see, there's supposed to be a date for, I guess, the comply with the court's order issued by a judge. Okay, so a judge is supposed to sign off on this. Number 2, defendant Carolina First Bank order to cease and desist, to be barred from any of the master transactions, blah, 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 blah. The defendants individually collectively doing business as a Washington's plantation to be ordered to cease and desist from using the bank account. Defendants cease and desist barred from authorizing any persons to hunt on the real property. Number 5, the defendants individually collectively doing business as a plantation ordered to cease and desist barred from cutting timber. Number 6, any and all heirs of Washington State be ordered to cease and desist barred from cutting timber. So forth and so forth. 7, be barred from the funds, transferring any funds. Okay, they're afraid any costs, Okay, so this was an order to appear and show cause. So I think it's pretty much the same. Yeah, this is the same. This is just saying that, hey, I'm gonna have a hearing on this date. Okay, so this is basically the complaint and the documents associated with the complaint, to include the ex parte order, the summons for the order to be heard in front of a judge, and probably the 12th. Who was it? The 12th circuit judge. That was right. Okay, get it right back up. Right. Let's see, for the 12th Judicial Circuit judge to hear this case, hear the order, the motion for the protective order ex parte, and the injunction. But again, I would have questioned this complaint, knowing what I know. I mean, granted, I was again not part of this complaint. I was not involved in 2011. I didn't return back to America. If you see my other videos, you know what I'm talking about. Where I didn't return back to America into late 2014, like October, November 2014. So I was not part of this, and I didn't get involved until I retired from the Air Force in 2016, and then hire the attorney and have our complaint filed and served upon the individuals that sued my family in 2017. So, but I mean, there's so much to this. This lawsuit went for 5 years, right? From 2011 to 2015. So in February of 2011, it was when they were served. Right, the complaint was filed and served upon the defendants, and in October of 2015 is when they had a jury trial. So, a span of 5-6 years. In between that time, there was paperwork being filed. These motions for an ex parte. Let me see. There's even motions for. Let's see if I have it here. For some reason, it's frozen. Motions for to be appointed as a sole trustee for the property. Because these are some of the exhibits right here, but these affidavits from members of my family who are named as a co-defendant in the case. We go here. Let me see. This is the answer counterclaim from TD Bank, or from the First Carolina Bank, against the plaintiffs. So this is their response to, hey, we did everything proper. There was no negligence on our part. Blah 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 blah. Every party is entitled to a response or a counterclaim, or present their case before you go to trial. Let's see here. So this is answer. So this is the defendants answering the complaint. So they can either confirm or deny the allegations. And I think that here that it says that that each and every allegation not herein specifically admitted, qualified, or explained is denied in strict proof demanded thereof. So basically, the defendants are saying, hey, I'm denying the allegations, but I demand proof of such allegations. All right. 2, that the defendants lack sufficient information to admit or deny the allegations contained in certain paragraphs there of the complaint, and therefore denies same and demands strict proof thereof. Number 3, plaintiffs deny allegations contained in paragraphs whatever of the complaint. So number 2 says that they don't have enough information to determine if the allegations are true or false, or they can admit to or deny to it. But the other 3, the paragraph 3 says The remaining paragraphs, they are going to deny the allegations. Again, each party has the opportunity to challenge the complaints and allegations. Where's the why is doing this? Okay. There was a hearing scheduled for something, and there was a hearing in May 2011. I'm not gonna go through all these documents, but just the ones that really matter here. So this is like a, see, go back up to the top here. Motion something. Motion for continuance. Okay. For some reason, something happened. They had to continue the hearing. Probably had to try another case that day. So, I mean, that happens where most attorneys will, if there's a conflict in their schedule, that they will ask for continuance or whatever the case may be. Okay, so here is a consent protective order. Kind of like what was filed, I guess, in the beginning, the protective order, the ex parte, that was filed. So I guess this is a I guess, okay, so let's see. This matter comes before this court upon the motion of the defendant TD Bank, with the consent of the above captioned plaintiffs and co-defendants for protective order pursuant to discovery request, is producing to the plaintiffs certain internal documents. So what is this? So I guess they're Carolina Bank, now TD Bank is filed this consent protective order to protect the information until you go to trial, or if it was a release prior to, maybe there would be an issue. Yeah, so they're trying to protect the information so that it's not released. It might be some sensitive information as far as like account numbers. Well, we already had an account number in there, but I don't know what exactly, unless I read into it further, but yeah, so TD Bank or Carolina First Bank filed this particular order to protect the information. Let me see here. Notice of hearing. So they had a hearing at some point in time. Why is all this jacked up? More consent order for continuance. Okay, so continuance again for whatever reason. Again, I mean this case lasted for 2011, 2015. Why is this? This is like 2011. Some of the documentation is 2012. See, motion to compel and sanction. See, come now, the plaintiffs by and through their unassigned counsel respectively move the honorable court for an order sanctioning defendant TD Bank, blah blah blah. Okay, so that's when the complaint was filed and served. Okay, pursuant to, okay, whatever. So what is this for? Are they turning over documents? I don't know. I can't read all this stuff. Let's see what this says. Plaintiff's memorandum. So okay. Yes, this is important here. So the plaintiffs in opposition to appoint a trustee. So I think it was in 2011, 2012. Let's see, what year is this? It says October 2011. So I think in 2011, early part of 2011, after being served the complaint, the defendants received it, right? They were served the complaint that members of my family filed a motion to be appointed as a sole trustee of the property until such a time that it can be resolved, right? The dispute can be resolved. So this is the plaintiff's response to that motion. So they basically drafted this document in response to the motion to make their argument. I'm not gonna read all of it, but Let's see, paragraph 1, defendants return to order and appear and show cause. A motion to appoint trustee was filed on or about March 4, 2011 in anticipation of the March 7th, 2011 hearing scheduled in court. The motion to appoint trustee claims the affidavits cannot be prepared in advance of the March 7th, 2011 hearing and none were offered at the time, nor is the motion itself verified by any defendant. 2 documents were attached to the motion appointee, but neither one was authenticated in any way. Neither one constitutes admissible evidence in the interim, blah, 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 blah. I mean, there's a lot of information here. I'm not going to read all of it. See, motion to compel all. Yeah, okay, I'm going to read all that. Motion, notice of motion, and motion to amend the answer. So I guess the defendants amended their answer. So now that, so I guess the first answer they provided was just to get it on record that, hey, that, okay, we deny all the allegations. But now I think the defendants, you know, in this document it says amended answer and counterclaim, that they had time to actually analyze the summons and complaint and put forth their a more detailed response to the allegations, or such as answering defendants denying allegation of paragraphs 1, the complaint, demand strict proof thereof. I'm gonna bounce around here. Let's see. You know, answering number 9, answering defendants are without sufficient knowledge and information to form a belief that's the truth with allegation contained paragraph 10, the complaint. I mean, some of them they're gonna admit, and some are gonna deny or say that we don't have enough information based on the way that the allegation is written. I mean, it's a standard I guess practice here. I mean, I'm surprised that there was no exhibits provided with the complaint. I feel like there's a motion for something here denied. Let's see what it is. I guess a motion to compel the sanction to basically get the defendants to comply with their request for whatever. It could be the interrogatories and discovery. Could have been something that they requested from the defendants, but it didn't happen. Order for relief. So basically, this document here, my understanding is that they're asking for relief, an injunctive relief, kind of like protecting restricting the defendants from use of funds from bank account, transferring funds, entering hunting leases, cutting timber, selling timber, a whole 9 yards. Moving trailers on the property. I'm gonna see that in here too. Yeah, from cutting timber, joining training from authorizing leasing hunting rights. Yep. From the bank, what's the bank gonna do? Yeah. And from transferring of funds, suffer to pay the taxes. So the property tax has to be paid every year. So, you know, so the plaintiff's answer counterclaim to. So this is the plaintiff's answering the bank's counterclaim against them. I can read all that. Again, I mean, this from 2011 to 2015, all these documents were filed with the court, you know, to argue their case, right? Motions for summary judgment against the bank. And I believe this is probably when my understanding, based on, you can talk to members of my family, do my research, that at some point TD Bank the case against TD Bank was dropped. They reached some kind of settlement agreement, and that TD Bank basically agreed to return the money that was utilized, that was withdrawn from the bank account, to hire a law firm. Because this was let me back up already. This was what started all this legal fight, was that members of my family were trying to figure out what was going on with the management of the property. Because by this time, in leading up to 2011, my grandfather passed away 10 years prior, at 2001. My grandma was still alive at that time, but other members of my family had died off. You know, my grandmother's brother, one member of their family, the plaintiff's family, died off, and my grandfather's mother had died off, which is my great grandmother, had died off. I think it was like 2006. She passed away, and so members of the family were dying off, but they were trying to figure out what's going on with the management of the property. Even had an aunt who's now deceased. She got involved too prior to the lawsuit being filed against members of my family to figure out what was going on. So that's why they utilized the money from the bank account to hire a law firm to do a title search on the property to start the process to acquire a title. Which, when I got involved, I utilized my money to hire a law firm to acquire a title to the property. Since we already had a large majority of the information from the title search done already, in that all we need to do was use that information to file complaints against the defendants, against those that sue my family, those that claim to be heirs to the property even though they didn't prove it. So that's what we did. There's a lot of information here, a lot of exhibits that they provided to the court to provide an answer to the bank, their motion for or their counterclaim, and then here is they tried to reach a summary judgment against a bank. They're trying to force the bank's hand, right? Because maybe they feel like the bank was negligent or whatever case maybe. They had a strong case to ask for a motion to do so. Because I could be wrong, but again, talking to members of my family, and based on what I know, is that when you sue a bank, you're looking for a payday. And maybe it was a payday. Maybe it was some negligence on their part, but you know, would it be in the hopes of thousands of dollars, or maybe 6 figures or more, 7 figures or more? I don't know. But to sue a bank, that, you know, my understanding that money is federally insured. So is that not federal? If you're suing a bank, it's not a local complaint. It should be federal. It should be heard in federal court, because that money is backed by the federal government. But I could be wrong. I'm not an attorney. You know, I'm just going off based on what I know, based on my research and reading and talking to members of the family. So you see here now is the check that was returned to, or at least returned from the law firm, and deposited into escrow account. I'm going to read all of this. I'm going to go through all this stuff here. I'm going to go at this and go to the next one. See what this is. More useless legal admin stuff. Again, I mean, it's going for like 5 years, so a lot of jumping around. So this, I think now is like 2014. So I guess they're still looking for a summary judgment against the bank. Maybe it's the same paperwork now, just coming around that it's being heard in front of the court. The information looks different, so I'm not really sure what. To me, yes, looks the same. Looks the same bit of information, so I'm going to cover that. Keep going over this. So it looks like the motion was dismissed for failure to prosecute. I don't know. Okay, so I think this is probably the last document, and I'm going to wrap up this video here. But so again, this is in 2012, but if you recall, in 2011, that members of my family filed a motion to be appointed as a sole trustee of the estate. I guess there was a hearing scheduled for January 17th of 2012. And I guess, see, the court or somebody is drafted this. And looks like it's been denied. It's been denied by a presiding judge. So there was a hearing on January 17th of 2012. Whoever gets a judge denied it, and this is his response on why he denied that motion. Looks like, let me see here. Honorable Judge Thomas A. Russo ruled in the same motion to appoint J. James Jr. sole trustee of the Washington Estate, ruling it was as requested to be denied. The Washington Estate has been governed by the Washington Association Board since its inception to the House to take over the estate's operations and financed by Mr. J. James Jr. family. The Washington James Estate is a multi-million-dollar property management of therefore. Mr. James has never resided on Washington Estate property or has never owned or operated a business, large or small, has no business management skills, and all the members of his plantation except two are family members. See, again, that's why I would question and challenge. It's important to have the paperwork to back up everything. Like, even the point where it says that Mr. Jack James Jr. has never resided on the Washington State property. Is that true? Prove it. Prove it that I never lived on the property. Prove it that I never owned and operated a business. Unless he was disposed on the stand, unless he was cross-examined on the witness stand and he gave that answer. That's one thing. But we don't have the transcripts to prove that. I mean, I would like to have the transcripts, but it's been some years, so I think that the court reporters keep the transcripts for like 3 years after that, or keep the recordings of the hearings for 3 years after that. They discard them. They don't save them. They delete them, or whatever case may be. But I would have challenged this to include, like, as far as I understand it, there is no law in the state of South Carolina that says that a person has to reside on property, especially heir property. I mean, you could be up north in, say, New York, Philly, New Jersey, Connecticut. I got members of my family that live outside the state of South Carolina. Granted, at one point they lived on the property, but yet their children and grandchildren have never lived on this property. So how can you deny them their rights to the property because they never set foot on this property, never lived on the property? Show me a law that says that. Show me a law that says that. If Mr. J. James Jr. or include myself or whoever can trace their liens back to the original owners of the property, even if they never set foot on that property, they still have rights to that property because his father, which is my grandfather, was born on this property, was born and raised on this property, to include my grandmother. So both his parents are heirs of this property when they were alive. Their parents had rights to this property because they were the grandchildren or great grandchildren of the original owners, Washington James and Toby Cox. So to say that he never resided on a property, okay, that may not be true, but is it a disqualifier saying that he cannot be a sole trustee of the estate? Now, maybe so about him not owning and operating a business, large or small, maybe so. But that does not qualify him for being an heir to property and having rights to the property, especially when individuals who claim that they were individually doing business as a Washington Association prove it. Did they prove it? Did he challenge them to do that? I would have challenged him and says, prove it. Prove it. Let's go. This whole point here where it says during the 6 months that his board had control of the daily operations, the Washington, was it 6 months? 6 months? I thought it was back in 2000 and, what year was that? 2008 or 9 or 6? Well, I can't remember. I get back in the beginning, but more than 6 months. More than 6 months. More than 6 months. Now, they're talking about as far as the bank account. But it was crazy. There was documentation to prove that letters were sent to Miss Alberta Nolan, Miss Catherine Lester, and other members of the board by way of attorney requesting for the books. So the financial books, the meeting minutes, the bylaws, all that to be turned over to the new board. They didn't do it. Why wasn't that presented here? Why wasn't it mentioned? It should have been mentioned during this hearing. Maybe it was. Again, we don't have the transcripts, but I would have presented that information and says, no, Judge, Your Honor, here it is. We requested this information. They didn't provide it. But, this is what the judge drafted up. Let's see, the last time the Washington State was governed by a sole trustee, it should be a solo trustee. The property was mortgaged and lost, and the county tax sale. That's not true. See, that's not even true, because here's the thing. Paragraph 1. In 1872, A. Evans sold 7 acres to the land Washington James and 18 others returned. That's not true. No, not true. The deed says, because I read the deed. I read the paperwork. In 1872, A.L. Evans sold the 700 acres of land to Washington James himself for $300. Nobody else was on that deed. Washington James, and then he mortgaged it for $100 in 1876, and he foreclosed on that loan in 1879. Paragraph 3. Paragraph 3 says that, and then in 1898, the 700 acres came back available, and he purchased that property along with other men and women, right? But before that, in 1884, 963 acres was purchased as an independent tract of land by Washington James, and it says here that 18 others, totaling 960 acres. So again, he's even in some of the information that he's basing off of is wrong. And I would have challenged it. Granted, this is after the fact. I would have filed a motion to challenge it. I would have filed a motion to challenge this motion for down the motion. I'd have came back with more information. I'd have came back and said, no, let's try this again. Okay, I don't need to be the sole trustee, but let's make it a board of trustees containing members of my family. But yeah, I see the judge's point in saying that, hey, he didn't have permission from the other heirs to do so. Yeah, valid point. So listen, I'll be going on for nearly an hour now. So I just want to cover the original complaint. What started all of this dating back to 2011. Before I got involved, before I came home, before I understood what's really going on with this case. Why does it keep on doing this? Nonetheless, again, things are ramping up. Things are heating up. I said things. This legal fight is ramping up. It's heating up. Members of my family are paying attention. Hopefully in the next few months that we'll have some kind of legal resolution and that we can move forward as a family, as a community. Those that have been identified as legal heirs of property can move forward and do what we need to do to manage this property collectively and do things proper. That's my whole purpose. The whole intent was, when I first got involved, is listen to my members of my family saying that these people are not heirs and handle business doing this. Well, let's go sue them. Let's and you understand from my family perspective, not everybody wants to get involved because they don't want to ruffle anybody's feathers, or they don't want to do this and do that because they don't want to hurt anybody's feelings. Maybe so. But you think somebody who is not an heir, who is not a family member, if they got their hands on this land, you think they're going to care about hurt feelings? I'm not going to care. So, anyways, with that said, I thanks for watching. I know it's kind of long with it, but this is a lot of key information here that needs to be said, needs to be put out there, needs to be discussed, whether in court, out of court. I just want to get out there for those that may be going through this, that might have experience in dealing with heir property and lawsuits. There's a lot of things that can be learned from this case, and my experience and everything else is, when it comes to lawsuits and dealing with family, things can get crazy. Feelings are going to get hurt. People will be mad and upset, mad and bitter. They're going to disagree. But if it can't be resolved outside of the court, this is the only way to go, really. It's the only way to go, especially when people's rights are being trampled on, people not giving a voice and allowed to be heard. This is the only way to go. So, again, this is, for me, is, not do or die, but I'm doing this for my family. And my grandmother passed away at 2020 at the age of 92. And her husband, my grandfather, passed away in 2001. I had my great-grandmother passed away in 2006. One of my grandmother's brothers passed away. I had other members passed away since then, and include my grandmother and one of her sisters who died at 94 years old in 2020. They died months apart. So, to me, this is about taking care of family, ensuring that me and my family, our righteous property is preserved, protected. Granted, there's more than just me and my immediate family or extended family, but there's a right way and wrong way of doing things, and with everything going on in the world, especially when it comes to heir property or owning land, that there's people out there that don't care. All they see is business. This is about business. This is about, they're not going to care about hurt feelings. They're going to care about the heritage, the history of the land. They're going to care if your ancestors were born on the property. They're not going to care. They're not going to care. They're not going to care one bit. So, only people going to have any kind of love and care for the property is family. So, family should work together, get it right. If not, you got to go to court. I mean, I'm not here to sell the land for nobody. I'm not here to steal the land from nobody. Even though it said that's my purpose, that's my motivation. No, it's not. No, it's not. I mean, there's a lot of naysayers, a lot of haters out there. But I'm going to keep pushing and do what I got to do to get it right. So, anyways, thanks for watching. Thanks for tuning in. Take care. See you in another video. Peace.